SJC-12414, Commonwealth v. Carlos A. Alvarez, Jr. Thanks.
Mr. Coase, good morning.
Good morning, Your Honors. May it please the Court. Matthew Coase on behalf of the defendant, Carlos Alvarez. Mr. Alvarez was arrested and his cell phone was taken from him. At some point after his arrest, the police officer heard the cell phone ring, looked at the unopened cell phone, and read incoming text messages. Given the height of protection that this court places on electronic communications, the officer's conduct was an impermissible search, and the denial of the motion to suppress should be reversed.
Why doesn't this fall under the plain view doctrine?
This doesn't fall under the plain doctrine simply because the Commonwealth failed to meet its burden in this particular set of circumstances. There's three particular reasons that I point to. First of all, even when the police are able to obtain a cell phone after an arrest, they don't have the ability to search through it regardless. There are limitations upon which an officer can search the cell phone. In this particular context, it's a little bit unclear why exactly the officer had the phone, what he was doing with it at that point in time. So I would point to an analogy of an inventory search. And so when an officer is doing an inventory of the defendant's or the suspect's personal items, they can take a look at their, they can take it from the person, they can note what is being received, they can identify the physical characteristics of that item, and they can place it for safekeeping. So in Riley versus California, which is the case that deals specifically with a search incident to arrest of cell phones, it basically indicated that the police could take an extra step with respect to cell phones. So it could remove the battery, it could open the phone to turn it off, it could place it in something called a Faraday bag in order to prevent the destruction of evidence. But there's no evidence on this particular record that the officer was undertaking either an inventory search or trying to place the phone in safekeeping. Rather, he heard it ring, he looked down and read the message off the screen of the phone, presumably off the screen of the phone. So his actions were somewhat more analogous to rifling through papers that have been taken out of a defendant's wallet upon inventory.
If the touchstone of the Fourth Amendment is reasonableness, the phone rings, what's the officer supposed to do? Go like that? I mean, is that what we want police officers to do? There's a phone right there and it's ringing and might involve narcotics, and that they're not supposed to look at the number?
Well, the case law does say that the police are certainly not required to put blinders on and ignore anything that they might see. But I would suggest as a solution here is, because this court has stated that there's a preference to obtaining a warrant prior to looking at the content of text messages, the officer could have applied for a warrant. He saw what he believed to be a hand-to-hand drug transaction on the streets of Worcester, and when he arrived at the police station, he saw the text message, probably more than one text message, and he could have put that into his application for a search warrant and searched the phone incident to arrest.
Well, be careful what you wish for, because are you suggesting, well, let me step back. Under Riley, I gather it is okay to seize a cell phone as incident to arrest, but not okay to search it. Is that accurate?
Yes, it is, Your Honor.
So it was okay for him to seize it incident to arrest. And it sounds as if there's no indication that he was treating it, that he was conducting an inventory or doing anything that would suggest that what he was doing was an inventory search.
On the facts of this case, Your Honor? No, there's nothing. the record is very silent as to what he was actually doing with the phone.
Okay, so best we can tell, he had seized it incident to arrest. He simply had laid it on the desk. I gather he was writing his report, and then it rings or buzzes or something, and he looks over. You're not suggesting that if somebody does not have probable cause for a search, he could simply sit there and say, I'm going to just watch this phone for the next 4 hours until I get probable cause to search this phone, are you?
No, Your Honor, that's specifically the type of unwanted conduct that we don't want to invite by allowing the plain view doctrine to kind of swallow up the search incident to arrest prohibition in this case. Again, that's an excellent point, Your Honor, because we don't know how long the phone was in his custody before he saw the text messages. Certainly what might be a reasonable viewing of the cell phone during a pat frisk or something like that, it may become unreasonable over time, as Your Honor noted, if the cell phone's in his custody for 2 hours, 3 hours, or days.
But wouldn't that go to the issue of whether it was inadvertent?
It would as well, Your Honor. I would note that would go to the issue of inadvertent, and I would also look at the police officer's conduct as well. He did not come across it inadvertently because it took 2 conscious acts to look at the text message. When he heard the phone ring, he looked at the phone and focused his attention, presumably away from his police report, onto the phone, and then he had to take the extra step to read the text message and comprehend what it was saying. So those 2 particular...
Didn't take very long.
Well, I mean, it does take conscious interpretation to understand what the text message is. Certainly this was a text message that the Commonwealth used expert testimony at trial to provide interpretation of.
Attorney Coase, I think I understand what you're saying, but do you think that there's a case, Commonwealth versus Seng, I don't know if you're familiar with it, from 2002, it's a murder case, in which Justice Cowan wrote that a police officer looking and recording the numbers on a debit card during a arrest or during an inventory search was too much because it involved consciousness and it involved copying down, and that she found that to be an investigatory search. I'm trying to see if there's a distinction between that debit card, because it was just account numbers that they took down, but the account numbers in those instances didn't have any bearing on the crime they were investigating. But here we do have a link.
Right, Your Honor. Well, I would also, I understand the court's analysis, and I do say it is helpful with respect to understanding the inadvertence requirement. But I would also point the court's attention to Commonwealth versus Sulla, which is an appeals court case that the Seng decision relies upon heavily. Mm-hmm. And in that particular case, the police officer went through a stack of business cards that were were in the defendant's pockets, and he found notations that he believed were consistent with gambling. I believe it was gambling cuffs was the phraseology. And this was after that he noticed that the individual was at a bar late night past the closing time. So in that particular case, the officer seemed to kind of jump to a conclusion that because he was at the bar and he had these notations, that he could be charged with a gambling crime. So in this case, there's not significant evidence of drug distribution.
Before you leave that, I'm just confused about your response to the chief's question, which is, how does time matter? I mean, if immediately after he's arrested, while he's got the phone in his hand and the phone went off, he can't look at that? I mean, and that would not be a plain view? Isn't that a classic plain view type of observation? You're there and you're seeing sort of evidence of a crime. I get there may be an argument that it becomes attenuated over time, if he sits around for days waiting for the phone to ring. But why isn't the first one clearly plain view? Why isn't that a plain view? If right after he arrests him, the phone goes off and it's not a phone that he has to open up and plug in anything, why isn't that plain view?
Well, on this particular record, we know that it didn't happen right after the arrest. but-
Do my hypothetical
Oh.
first, then.
Yeah, and I think that there's the unpublished decision from Wisconsin that is very
little-
similar to
Very
your.
little interest in unpublished from Wisconsin. How about just your own view of facts on this?
Right, so if an officer in that situation is conducting a pat frisk or something like that and looks at the phone, then it would be possible under that particular fact pattern to view the message in plain view.
Okay, so let's then take it, he's got the phone, he goes back to the office, which I'm not sure we can tell that's what's happened here. I haven't read the transcript of the motion to suppress it. Is it clear that he's at his desk typing his report that day and he sees it, or we can't discern that?
No, not from the record before the motion judge. The judge, the Commonwealth, the judge, and the motion judge and defense counsel did not spend a lot of time on this particular issue. It's entirely unclear what the officer was doing at the time and how long he had the phone. He was asked how long, did you see some messages? He said, yes, I did. Did you have to open the phone? No, I did not. And then on cross-examination, I think he says he was at the police station and it was in his custody. But again, he testified at trial that he was writing the report. Plus, it's also very important to note that the content of the text message actually did not come out during the suppression hearing. The Commonwealth did not ask what the text message said or why it was relevant or how it was connected to this particular arrest.
But it was used in the trial, right?
It was used in the trial.
And was there ever a search of the phone?
There, not to my knowledge.
Well, my question, I only asked that because you mentioned that, I think you said that the police officer could see what was on the phone and then get a search warrant for it? Try to apply for a search warrant based on what he or she saw on the phone?
Well, if the police officer had enough to apply for a search warrant and seek information, then that could be used as one of the components.
But if it could be used as a component for a search warrant, why couldn't it be used as evidence at trial?
Because this court has specifically stated that it has a preference before the content of text messages be searched, that a warrant be obtained, or that there's a certain expectation of privacy.
So you're saying a search for what he's already seen, just a search for the statement that he has seen and he's looked at, then there should be some sort of process for him to be able to use that statement?
Well, again, Your Honor, yes, I do think that there has to be some sort of more fervent procedure in place in order to use that particular statement at court, given the expectation privacies that we have in the content of our text messages, and this court's preference to obtain a search warrant in those situations.
Mr. Coase, so the problem here is we've got Chief Justice Gantz's question about hours looking at the phone. We've got Justice Kafker's hypothetical about the phone rings as you're maybe doing a search or inventorying the phone, putting it in a bag. But that doesn't appear to be the facts here. So one of the problems is that, and you've already alluded to this, we don't really know what the facts are here. As a matter of fact, we don't know if there's more than one message. It seems from the transcript like there was more than one text message. So if you, I can't imagine human nature, common sense, the phone has a message, as you're putting it in the inventory bag, looking at it, that would be inadvertence. But if it's going crazy with text messages, or even if it's the second or the third one, it might be different. And my problem is, and maybe this is a better question for your sister, my problem is, so what are the facts that we're applying this doctrine to?
That's correct, Your Honor. You're right. There is evidence in the record to support that the officer read more than one text message, and I would suggest that that obliterates the inadvertence requirement. And with respect to the other requirements, the Commonwealth did not meet its burden to show that the plain view exception was applicable in these circumstances.
Yeah, but there's a line somewhere. So you're starting to inventory everything, and there's a text message. Okay. Then 2 seconds later, there's another one. That's different than 20 minutes later, as the Chief was alluding to, you're sitting there just looking at the phone. But I guess in order to apply a doctrine, we need facts. Do we have them?
I don't think that the Commonwealth made its case. The burden is on the Commonwealth to demonstrate that the plain view exception would apply. From my reading of the judge's conclusions of law, I'd suggest that he found that it was a lawful search incident to arrest by citing to the Berry case. But even if the court goes beyond that and looks at what would be required under the plain view exception, I still think that the Commonwealth fell short of meeting all of those criteria. And unfortunately for them, they did not develop the facts in order to sustain that burden.
In fairness to them and in fairness to the judge, I believe at the time, Berry was the governing law, was it not?
At the time of the arrest, I believe Berry was the law, but I believe the suppression hearing took place in 2015 after the Riley decision.
Okay.
And I believe that defense counsel, he cited it as Worry, but that's the companion case.
Okay.
Thank you.
Thank you. Ms. Lazar-Moore, good morning.
Good morning. Ellen Lazar-Moore for the Commonwealth. The motion judge correctly denied the defendant's motion to suppress because the text message at issue here was in plain view. To clarify the timing, the arrest did happen, I think, before Riley. The suppression hearing did happen after Riley. The prosecutor did not argue that it was a search incident to arrest. He argued that it was in plain view. The judge's findings are a little bit unclear because he doesn't use the words plain view, but he says twice that he made observations of the messages that appeared on the phone. He did not open the phone or search its contents. He simply observed information on the screen of the lawfully seized phone. But then he just says, see Berry.
And do we know, was there testimony about when the police, I haven't read the transcript yet. Was there testimony from the police, uncontested testimony from the police officer about when he observed this? I mean, was it 3 days later? Was it 2 hours later? You know, do we have
Not in
anything like
terms of time at the suppression hearing. At the trial, he does testify that it was when he was writing his report, but A, I know that's not before the motion judge, and B, they don't say when he was writing his report.
So what do we do with that? Because obviously if it were a month later and he's just sitting around waiting for texts, that's different, right? How do we get around the factual problem that Justice Lowy has identified?
Well, Your Honor, he says that upon arrest, he searches him. And what did you find? In this pocket, a $20 bill, in his right pocket, this other amount of money. What else did you recover? A cell phone. Did you attempt to open it or look at it? No. Did you see any messages come up while it was in your custody? Yes. Did you have to open it in any way? No. That's all he says on direct at the suppression hearing.
I mean, can we take judicial notice of the battery life of a phone? I mean, how do we know when this Mine dies every day, but I'm not sure I can take that into
No,
account.
I know, Your Honor. And then just to add to that, on cross, during the suppression hearing, the defense attorney asks him, in any event, you looked at the phone as it rang at the police station, yes, and you read some messages from the phone, yes. So it's not clear exactly how long the time was, but I would argue that whatever it was reasonable, because based on the judge's findings, the judge finds that the officer's just in possession of the phone. He's not searching the phone. He's not opening it. He's not flipping it. He's not answering it. It rings. He looks at it. He sees this one text message. It is unclear whether there was one message or more than one message. I believe the record is more suggestive of the fact that there was only one, because the prosecutor says, did you see any messages? And he says, yes. And then the prosecutor said, did you have to do anything to the phone to see that message?
But
And he
the judge says
no.
messages in his findings, right?
Yes, the judge says, he does use the word messages, but again, there's no direct testimony to the number of messages. But if this was reviewed just based on whether this was reasonable, I would argue that it's reasonable. There is no suggestion that he did sit there staring at the phone, and certainly there would come a point where it might become unreasonable and become something more akin to a search. But there's reference to a single text message which comes up on a phone that's lawfully in his custody, that was seized incident to arrest, with no search, with no manipulation of the phone. So the officer was lawfully in a position to see the phone, and based on the training and experience that he detailed with over 1,000 arrests and investigations in this one very high drug area, I think that the judge could conclude that the officer would know that this message is plausibly related to crime about which he's aware. And in terms of inadvertence, when there's just a single message that's discussed and it pops up on the phone with no manipulation by the officer, I would say that that's even more sort of inadvertent than what has been approved by the court in terms of plain view searches of things like written documents. I cite in my brief I'm sure I'll mispronounce this, but the Schleich-Brodeur case, where the officers have a search warrant for certain materials, not including written documents or papers. And when they're in the house, they see papers and they're allowed to scan or peruse them at least somewhat quickly to get an idea of what they are. And as it turns out, they realize with that quick scan that it does have relevance to what they are searching, and they're allowed to seize them because they're in plain view. And I think that that's even more of an examination than what we have evidence that happened here. And yet the court has approved that, and that's longstanding law.
But that's different, because they have to read the stuff to see whether it falls, in Schleich-Brodeur, and I forget the precise facts, but they had to read stuff to see whether or not it was going to be evidence pursuant to the warrant. So they had to read some things just to at least say it's either in or out.
Well, not really, Your Honor, because in that case, specifically the warrant did not include any kinds of writings or documents. I think they were there looking for bloody clothing,
So there were no writings, you're saying, and it was not as if you say writings regarding X and they had to look at writings and this involved Y.
Exactly. The writings were not listed as items that could be searched for under the warrant, and yet when they were there and they saw them, or in other circumstances, I cite another case, Commonwealth versus Young, where they are in this place based upon exigent circumstances. There's a trail of blood and they follow it and they're looking for the body or the blood or the injury or the weapons, and they see some papers and they read them quickly just because human nature. You look at writing and your brain absorbs what it says, and it's not a full-blown search, but it's been approved of as plain view, inadvertent viewing of writing. And so I think here, this is even less intrusive than what happened in those two cases, which was upheld under the plain view doctrine. And I think even in the Riley case that the defendant relies very heavily on, the court said, no, you can't do a full-blown search incident to arrest of a cell phone because the two sort of animating factors that allow search incident to arrest don't really apply to a cell phone, but they do say you can still do some limited examination or manipulation of the phone. You can look at the outside, you can look inside the case to make sure there's not a razor blade, you can turn it off, you can take off the battery, you can put it in a bag, you can disable the auto lock mechanism. Certainly, during all of those things that you're allowed to do with the phone, you may see something, and there's no suggestion in the case that the officer has to turn away or do all this with his or her eyes closed or ignore what they see. And if the court approves that amount of examination or manipulation of the phone, also recognizing in Riley they say, but other traditional exceptions to the warrant requirement might still apply, and they specifically talk about exigent circumstances, but plain view is obviously another one of those traditional exceptions.
So let's think of what the rules are going forward for police officers based on this case, because this happens every day.
Yes.
Police officer arrests somebody, drug by bust. It's okay to seize the phone, incident to arrest, I gather.
Yes.
It is not okay, despite what we said in Berry, to sort of go through and scan let's see who the person called recently, let's see what the recent texts are. So you can't do that.
Right.
And if you want to search the phone, you need probable cause.
Right.
Okay, now, in this particular case, they probably did not have probable cause to search the phone, because I don't think they even observed any activity on the phone, so they didn't have
I
probable
agree.
cause at the time. Can they sit there and put the phone next to that person and say, I'm gonna watch for texts coming in, and that will show me that the phone in fact is used for drug distribution, and that will give me probable cause to search?
Then I think you don't satisfy the inadvertence requirement. I don't think that the sort of physical use of your brain to read something means that it's not inadvertent, but I mean, the way that the cases have defined what inadvertence is, it's essentially that before you encounter the item, you don't have probable cause to believe that it's there. So if you go into the house with a warrant for physical evidence like bloody clothing, but you pretty much know that there are also papers there, but you don't include that in the warrant, well, then you didn't inadvertently come across them. And I think that would probably be the same thing that, well, you have the phone and you're just staring at it for 4 hours waiting to see if something comes in. That, I'd say, would go beyond what the plain view doctrine allows. But for the most part, it's going to be a very fact-based, case-by-case analysis, as it always is, with any plain view argument or any exception to the warrant requirement or any examination of whether what someone did was reasonable under the Fourth Amendment. And I think that this was at one end of the spectrum where something like that would be at the other end of the spectrum.
Can you, can you address the trespassing? I find that a little difficult. I mean, it's a grocery store parking lot, right?
Yes.
They've got no trespassing signs on, but obviously it's not a conventional no trespass, because they want all the people using the store to trespass, right?
Right. Well,
and
not
actually-
to trespass, but to come in.
Excuse me, come. And then they have further complicating things. One of the buyers lives in the residential area where the parking lot is. So I guess this parking lot serves more than just the store.
Right, well, he did not live there. The woman who he was with
I
lived
understand
there.
Tet, or whatever her name is, lived there.
Yes.
So is this really a trespassing case?
Yeah, I think it is, Your Honor. I think the element of trespassing to which you're referring is entering without right, and the question is whether they entered without right. And I believe that they did because the evidence showed that they really didn't have any legitimate purpose for being on the property. I cite cases that discuss the fact that inviting someone in may give sort of an implied limited license to come on the property for legitimate purposes, but once that purpose has been served, or once your legitimate purpose is completed, it does not give you license to just remain there for illegitimate purposes. And I cite one case, for example, where someone does his food shopping at the grocery store, and then he wants a free bottle of detergent that he thinks he's entitled to, and they won't give it to him, and he won't leave. Now, that is also a case where he was specifically directed to leave as opposed to just notified by signs, but it's a grocery store. He was clearly entitled to go in, he was invited to go in, he did his shopping, but then his legitimate purpose was over.
Every time someone's on private property doing a drug deal, they're also going to be subject to prosecution and conviction for trespassing then.
If they've been forbidden to do so by either verbal or posted notice. And in this case, there was evidence that there were at least 2 signs, that they had to walk by the no trespassing signs in order to get to the area where they were doing the drug deal. So it wouldn't just be that everyone who walks on, if there had not been no trespassing signs
If you have a
posted.
no trespassing sign at this grocery store and you're there for any reason but buying stuff at the store, you're trespassing?
I
You park
suppose,
your car to answer your phone and make a phone call because you've got a good connection. Are you trespassing?
I'm not sure. I suppose that would be sort of a factual question of whether that's a legitimate purpose for being in that parking lot. Technically, I suppose an argument could be made that it's not if you do that every day, or you bring your friends to use 10 spaces and there's no room for the shoppers. But clearly that's not the facts here. They meet in this parking lot, the jury could infer, for the sole purpose of doing a drug deal. They don't go in the store, they see the police officer, they signal, go in the back, they're in the shopping rack.
There's 2 stores there, and they have that sign saying this is only for customers of blankety blank. And I'm actually shopping a little further up, and I park there because there's no parking there. I'm trespassing?
Well, I suppose, I don't know if there's a distinction between you may only park here if you're using Trader Joe's.
You know, we got all those stores that want their spot.
Right.
And so they say, don't park there unless you're doing it. And then,
Right.
because I'm using the store 3 blocks up,
Right.
I'm going to be much more careful after this case.
No, you shouldn't do that.
Don't you need someone to say, you're trespassing, get lost?
I was going to say, I'm not sure that this sign, this parking is only for Trader Joe's, is the equivalent of a sign that says no
Well,
trespassing, no
assume it says no.
loiterers,
Let's assume it
violators.
says no trespassing.
Violators will be prosecuted. Then I think if you are on their property, then you are on their property without right, using it for a purpose for which it's not legitimate, it's not what you're invited there to do, then technically you probably are.
And isn't there an element that says you have to essentially defy a request to leave? Isn't that?
No, it's either after being forbidden to enter the property directly or by posted notice, or after having been asked to leave and refusing to do so. So there are different ways that the statute can be violated.
So when Justice Kafker says to, his kids are too old, but if kids younger, okay, the soccer team's gonna rendezvous in front of the Trader Joe's, we're gonna park there and then go to the away game, police can say, okay, round them up, they're all under arrest.
I hope that that doesn't happen, but
But you're saying it legally, we should say legally it can?
I think, again, that, a lot of these are the kind of factual distinctions that a jury or a fact finder has to deal with. Is that entering without right? Is that having been forbidden to do so?
Well, it says no
I think-
trespassing, and he's not there to shop. He's
Right,
there
and-
simply to rendezvous and to leave cars there so that they can be efficient with their gas consumption. And build team loyalty. Police, the shop owner can say, no, I want them arrested. Police officer comes by and he says, okay, tell him to leave. He says, no, I actually want him arrested because Commonwealth versus Alvarez says that I'm entitled to an arrest.
And he's a repeat offender.
Right, well, obviously, the officer can exercise some discretion, but if it is someone who's parking their car there every day so that they can catch the train, then I think, yes, that's a technical violation of the statute. And if the private property owner, it's his rights, his property being violated, then yes, he could ask for that person to be
Well,
arrested.
it's not really an academic discussion either, because it's like a potential 30 days more for any drug deal. And you might have a district court case where you don't get the conviction for the drug deal, and then there's a 30-day maximum on the trespass. So this is actually not just interesting question, it's a really important question.
Oh, I know. I mean, here, the other defendant, Mr. Gomez, was only arrested for trespassing because the deal was never completed and nothing was found in his pocket, so that was the only thing that he was arrested on. So I understand this is not simply academic, but I think certainly some of these scenarios are very far removed from what we're dealing with here. But I do think that if there are signs forbidding trespassing in multiple locations and the people are on notice of it and they're entering without right and using the property for something other than what it was intended for, then, as I said, although I think there's an implied limited license to use the property for its intended purpose, if you go beyond that or your business there is done, then you are trespassing.
Ask you one question about the admissibility at trial of the text message, not about the best evidence rule, but about the hearsay objection, which you don't mention in your brief. That text message is seeking to buy drugs, right?
That was the interpretation
That's the
of
theory
the
of
expert, yes.
admissibility.
Yes.
Well, why aren't those legally operative words?
Okay. I did address the hearsay exception in my...
I know, but why aren't they just legally operative words? I want to, I'll sell you this pen, I'll buy it. That, with a contract, this is the words of a crime. Why aren't they just legally operative words and the analysis is as straightforward as that?
Well, I think that one of the cases that I cited does use that analysis. I focused mostly on the intent and state of mind because that was what the judge limited it to, and the judge instructed the jury that they could only consider it for that purpose. That was the argument of the prosecutor. And I cite other cases, DePina in particular, where there was similarly someone answers the phone during the execution of a search warrant for drugs, and the person on the phone says, like, can I have a big 50?
Those are the bookie cases, though, as well. The bookie cases are legally operative word cases. They're not state of mind cases.
Yes, and those were I cite Washington, which relies on the bookie cases, which are the operative word cases.
Right.
And I think it's sort of a similar analysis that it's not, either way, it's obviously not for the truth of the matter. In this case, it's not for the truth of the fact that this texter needed some. It was for the defendant's intent or state of mind, and so that was the purpose for which the judge limited.
The words of the crime, the fact that those words were spoken, legal consequences flow. That's a request to buy drugs.
Right, but I think the basis of the conviction for possession with intent to distribute was not based upon that text message. I think that was more circumstantial evidence of his intent, and that the possession with intent was based upon the attempted drug deal with Mr. Gomez.
Okay, thank you.
Thank you.